Today I'm showing you 5 clauses that can save you from defect lawsuits. Now these aren't theoretical concepts. They're battle-tested provisions I've used to protect developers across Florida when defect claims hit. By the end of this video, you'll know exactly how to structure each clause and why it works to either prevent litigation entirely or dramatically reduce your liability when claims do arise. I'm Santiago, Cueto, board-certified international business law expert and best-selling author. Just last month, a developer walked into my office with a $7 million lawsuit over foundation cracks in a condo project that they were working on. The homeowners association was demanding full replacement. Now here's what saved him: a single clause in his construction agreement that most developers overlook completely. That clause alone reduced his exposure by $6 million. Now let's start with the notice and opportunity to cure clause. This one stops lawsuits before they even start. Now here's how most defect cases begin. A homeowner sees water damage. They call an attorney immediately. That attorney files a lawsuit within minutes. You find out about the problem only when you're served with papers. Now you're in litigation mode. Discovery costs pile up, your insurance rates climb, your reputation takes a hit. Now the notice and opportunity to cure clause changes everything. It requires the homeowner to notify you in writing before filing any lawsuit. Not just notify you, they must give you a reasonable time to inspect the alleged defect. Then you get the chance to fix it. Florida law actually encourages this approach. Chapter 558 of the Florida statutes creates a framework for pre-suit notices in construction defects. But the statute does have gaps. Your contract needs to fill them up. Your clause should specify the exact notice procedure. Certified mail to a designated address, a detailed description of the defect, photographs if possible. Then set your inspection window. I recommend 30 days minimum. That gives you time to bring in your engineer or contractor to evaluate the claim. Next comes the cure period. This is where developers often make mistakes. They write vague language like reasonable time to repair. That creates disputes. Is 60 days reasonable? 90 days perhaps? Who decides? Be specific. State the exact time frame based on the type of defect. Minor cosmetic issues might get 30 days. Structural concerns could warrant 90 or more days. Match the timeline to realistic repair schedules. And include one more critical provision. The homeowner cannot file a suit during your cure period unless you fail to start repairs in good faith. This keeps them from using the notice requirement as a mere formality before rushing to court anyway. I've seen this clause reduce litigation by 70% in some developments. Why? Because most defects are fixable. Most homeowners would rather have repairs than lawsuits. I mean, who wouldn't? When you give them a clear path to resolution, they take it. Now, the second clause is your limitation of liability provision. This one caps your maximum exposure. Construction defect damages can spiral out of control fast. Start with the repair cost. Add diminished property value. Throw in consequential damages like temporary housing cost or lost rental income. And before you know it, a $50,000 repair becomes a $1 million claim. Now, a well-drafted limitation of liability clause puts a ceiling on top of all this. You define the maximum amount you'll pay for any defect claim. That amount should reflect the scope and scale of your project. Now, Florida courts generally enforce these clauses if they're reasonable. The key word is reasonable. You cannot limit liability for gross negligence or willful misconduct. You cannot completely eliminate all remedies, but you can set rational boundaries. Now, here's the formula that works. Cap liability at the purchase price of the unit or property. So for a $300,000 condo, your maximum exposure is $300,000. Courts view this as reasonable because the buyer isn't paying more than what they paid for the property in the first place. It makes sense. Add another layer of protection. Exclude consequential and incidental damages entirely. That means you're not paying for the homeowner's hotel costs while repairs happen. You're not covering their lost rental income. You're not responsible for emotional distress claims. You fix the defect itself or pay the repair cost. That's it. Now, before I show you Clause 3, do me a favor, hit that like button right now if you're finding this valuable, and subscribe to this channel so you don't miss the contract provisions I share every week. These are the exact strategies I use with my developer clients. You're getting the real playbook here. Now, clause number 3 is your express warranty and disclaimer section. This defines exactly what you're promising and what you're not. Most developers make one of two mistakes. They either overpromise to make sales, creating warranties they never intended, or they include boilerplate warranty language that doesn't match Florida law. Your warranty clause needs 3 specific components. First, specify what you're warranting. The structure will be free from material defects in workmanship for 2 years, for example. Now, the roof will be free from leaks for 5 years. The mechanical system will function properly for 1 year. Whatever you promise, make it clear and measurable. Second, state your exclusive remedy. If a warranty defect occurs, you will repair or replace it. That's a homeowner's only remedy. They cannot sue for damages. They cannot rescind the purchase. They get repairs, period. Third, disclaim implied warranties to the fullest extent Florida law allows. The implied warranty of habitability, the implied warranty of fitness for a particular purpose, the implied warranty of merchantability. Your agreement should explicitly state these do not apply. Florida law is crucial here for condominiums. It allows developers to limit the implied warranty of fitness and merchantability through conspicuous disclaimers in the purchase agreement. The disclaimer must be in uppercase text or bold font. It must be clear and unambiguous. I always include a separate acknowledgment section. The buyer signs a statement confirming they've read the warranty provisions and disclaimers. They understand the limitations. They accept them as a condition of purchase. This destroys any later argument that they didn't know about the limitations. Now, the 4th clause is mandatory arbitration or alternative dispute resolution. This keeps you out of court entirely. Jury trials are dangerous for developers. Juries sympathize with homeowners. They see the individual buyer versus the big developer. They award inflated damages. They don't understand construction complexities. An arbitration clause eliminates all of this. Now, your clause should require binding arbitration for any dispute arising from the agreement. That includes construction defects, breach of warranty claims, and any other controversy. Choose your arbitration forum carefully. I typically recommend the American Arbitration Association Construction Dispute Resolution Procedures. The arbitrators understand construction. They apply the law correctly. They issue reasoned awards that are enforceable. Include important procedural provisions. The arbitration will occur in the county where the property is located. Each party bears their own attorney fees unless the arbitrator decides otherwise based on frivolous claims. The arbitrator's decision is final and binding with very limited appeal rights. Some developers ask whether arbitration clauses are truly enforceable in Florida for construction defects. The answer is absolutely yes. Florida has a strong public policy favoring arbitration. The Florida Arbitration Code governs these agreements. Courts routinely enforce mandatory arbitration clauses in construction contracts and purchase agreements. And here you want to add one strategic provision. If the claim is under $50,000, the arbitration will be conducted through document submission only. No hearing, no live testimony, just written submissions and evidence. This dramatically reduces costs for minor disputes. All right, here's the 5th clause. The 5th clause is your indemnification provision. This shifts responsibility to the parties who actually caused the defects. You're the developer, but you didn't personally install the plumbing or frame the walls. Subcontractors did that work. Your indemnification clause makes them responsible for defects that they created. Structure it as a mutual indemnification initially. Each party indemnifies the other for damages caused by their own negligence or breach of contract. Then add specificity for construction defects. The subcontractor specifically agrees to indemnify you for any defects in their work. That includes repair costs, legal fees, and any damages you incurred defending or resolving defect claims. Florida law requires careful drafting here. You cannot indemnify against your own negligence through broad form indemnification clauses. Florida law prohibits this in most construction contracts. Your clause must tie indemnification to the actual fault of the indemnifying party. And make the subcontractor's insurance a backup. Require they maintain general liability coverage with completed operations coverage. name you as an additional insured, and require the policy to remain active for at least 3 years after completion date. That way, their insurance pays before you have to pursue indemnification directly from the subcontractor. Now, these 5 clauses creates layers of protection. The notice clause stops premature lawsuits. The limitation clause caps your exposure. The warranty clause defines your obligations, and the arbitration clause controls the forum. Finally, the indemnification clause shifts responsibilities to the right parties. Every developer in Florida needs these provisions in their contracts, not generic versions pulled from the internet. Customized clauses that fit your specific project type, your risk profile, and current Florida law. Now, if you found this valuable, give this video a like right now and subscribe to my channel for more legal strategies I share every single week. These insights come from decades of representing developers in high-stakes disputes. You won't find this level of detail anywhere else. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.